Hello, welcome to the ICC Annual Arbitration and ADR Conference. We'll be making a start shortly. We're just letting people get onto the system, onto the session. Thank you.
Natalie, are we good to start?
We are good to start, Anya. All over to you.
Thank you. Good morning, everyone. It is a great pleasure for me to welcome you to the ICC UK Annual Conference, and in particular, this morning's session. I have a few things I'd like to run through this morning. First of all, you will have seen that we are using our new virtual platform Swapcard. I hope it's all working out for all of you and that you've had a chance to log in and check it out earlier this week. I believe, though I haven't tried it myself, that you can connect to others, the other participants on Swapcard, and you can meet up with them without the need for individual Zoom links. So I hope you're all enjoying that function, and we'll be interested to hear your feedback on it in the chat room. So this week we have 7 webinars and 2 roundtables as part of a 3-day event. You are hopefully watching a lot of them live, but if you're not able to, all of the webinars will become available on demand via, I believe, also the Swapcard app. Excitingly, we have, Natalie updated me this morning, over 300 participants from over 42 jurisdictions. So one of the advantages, of course, of having our conference virtually, though, of course, I'm disappointed not to be able to see you all in person. A big thank you to Natalie and everyone at ICC UK for putting such a fantastic programme together. They've been working very, very hard. And also an enormous thank you to Opus 2, who are sponsoring this event. Very shortly, I'll be passing over to Harry Matovu QC, who's going to be opening today's programme formally for us and introducing some of the themes that we are going to be looking at over the next 3 days. But before I do that, please also, can I remind you that if you have any comments or any questions that you want me or the other speakers to see, could you post them in the questions box in your Swapcard app rather than the chat room. So thank you again, and over to you, Harry.
Well, thank you, Anya, and good morning, everyone. I hope there are no cats among us. Very pleased to be here. I haven't had to get dressed in ages, so this is a welcome change. You'll be delighted to hear that I've been told not to detain you for very long. In so doing, I feel rather like an unreliable uncle at a wedding with strict instructions to say very little in his speech. Just focus on the bride, they told me. Say how you're related to her, say something nice, and then get off the stage. Well, I'm going to exercise the full privileges of an unreliable uncle, and I shall be unreliable, ungovernable, and ultimately unrepentant. I have been asked to say and to offer some, I think what they say is insights from ICC's relationship with the corporate community. Now that feels like a perfect theme for an unreliable uncle's wedding speech. You may be expecting stories of the ICC and her string of past lovers and mésalliances, but in fact, my theme is not retrospective, it's going to be forward-looking, because I want to invite you all to enjoy a warm and close ménage with the ICC. which may be rather modern, as the dowagers amongst us might think. But before I'm hustled off this stage, I should say that I'm not being quite as disreputable as some of you may hope, because I'm speaking as an arbitration practitioner of long standing and as a new member of the board of ICC UK. And from both vantage points, I'm struck by the opportunities that there are for all of us to leverage the relationship between the ICC officers around the globe and its arbitration arm, the ICC Court of Arbitration. And as you all immerse yourselves in the details of arbitration law and practice over the next 3 days, and as you reflect on what you shall have heard over the following months, it's useful in my mind to keep in view the purpose for which international arbitration exists and the unique global organization under whose auspices we are gathered. International arbitration is a creature of business, and it exists for business. If party autonomy, the foundational principle of arbitration law, tells us anything, it should be that. Now, at first sight, that may seem a rather hackneyed platitude, but look more closely and see what that suggests about ICC arbitration. Because it seems to me that ICC arbitration is capable of offering something uniquely different from other arbitral institutions operating in today's world of globalized and increasingly digitized trade and interconnected economies. We arbitration practitioners and users of the ICC arbitration system appear sometimes to lose sight of this. ICC arbitration is, after all, the creature of a 100-year-old organization which represents 45 million companies of all sizes and sectors around the globe, employing 1 billion people in over 100 countries. It's the only business organization with UN observer status at the UN General Assembly. It's a network partner of the G20, a strategic business partner of the World Health Organization on COVID-19, and also of the World Trade Organization. It's a business focal point to the UN on climate negotiations. And the ICC, as an organization, drives global initiatives and debates to tackle such issues as the pandemic, trade reform, climate change, sustainability, digitalization, and access to finance. And the UK branch of the ICC, the oldest of these offices, represents some of the largest and most successful international companies around, such as BT, Diageo, Google, HSBC, Unilever, companies with large value chains operating in more than 170 overseas markets. And it counts among its members all manner of businesses, leading law firms, and also even barristers' chambers. All are welcome. It has access to UK embassies, government trade teams, every foreign embassy, every foreign business group, and it's doing extraordinary work in harmonizing digital trading standards, climate action, leading business engagements in the run-up to COP26, finance for development and anti-corruption work, etc., etc. It's working with government to reform English law and to enable paperless trade through digitization. Well, so what, you say? Well, as I reflect on this, I find it interesting that people are not talking much more loudly about the huge untapped strength and resources that the ICC has as a global organization, resources to develop arbitration and dispute resolution law and practice as an adjunct and an aid to global trade and economic growth. The ability to lead thinking through the insights and shared experience of its members on the development of substantive and procedural law in important ways to facilitate and support the increasingly rapid innovations in trade and business that we're witnessing with digitization and technological advances of all sorts, to promote the development of new markets with new customer requirements for contract performance and dispute resolution, to contribute to the development and growth of new financial products and their assurance with effective and reliable dispute resolution systems. And I wonder, when I think about this, why the ICC Court of Arbitration is compared as an arbitral institution only to other arbitral institutions which don't have the same history, or crucially, the same ability to harness and to leverage the trade, market and finance expertise that the ICC UK and other ICC officers have. And you're going to hear in this conference about the remarkable rise of Singapore as an arbitral center. It's remarkable indeed. But why should that be the main story in Arbitration Town? And that leads me to my next point. It's not original, but it's fundamental. Arbitration is often viewed in practice as a thing apart from trade, a silo where one goes when a relationship breaks down, not as an integral part of the ebb and flow and growth of trade. And on that somewhat cyclopean view, it has developed as a specialty with a circuit of practitioners, often and increasingly criticized as something like a club. Now, if international arbitration is to grow, it seems to me that it needs to maintain and increase its credibility as a dispute resolution system to service global trade and markets around the world. And it cannot do that unless it substantially increases the diversity of its practitioners, its practices, and its outlook. We need to do more on this. I speak not just of gender diversity, which is so often the principal target of initiatives in this area, but also of racial and cultural diversity, which should surely be the focal diversity issue in any sector concerned with the facilitation of global trade. And different operators in different markets have different needs and expectations for the resolution of their disputes. And so it is that the ICC, with its deep experience of its global membership, can and should be at the forefront of this, learning from business and professional members, promoting debate among business and professional members, establishing and developing schemes for the development of arbitral talent from across the globe, through perhaps secondments and placements in arbitration practices, and even appointments to tribunal secretarial positions. And so, as the world begins to contemplate the resumption of vibrant economic activity after the pandemic, let the ICC move forward with this renewed purpose, to harness both its business membership and its arbitral practices and expertise, to develop global trade and capital flows, to build capacity around the world in dispute resolution techniques and expertise, which will then enable that capital to continue to flow around the world for the benefit of all. So now, you'll see I've said something nice about the bride, and now the unreliable uncle will stagger off the stage towards the nearest bar, and I shall make way for the main event. I wish you all a very enjoyable, instructive, collaborative, and thought-provoking conference. Thank you.
Thank you so much, Harry. And of course, Harry is a member of the ICC UK board. And thank you for that important reminder of...
And good morning, everybody. I think in this audience, Alexei Morili is someone who needs no introduction, but in the usual way, I shall introduce him anyway. So to remind everyone, Alexei has been president of the ICC International Court of Arbitration since the 1st of July 2015, serving before that as vice president from 2009 to 2015. But his experience isn't just with the ICC, he's also served as a co-chair of the IBR Arbitration Committee, an LCIA court member and a council member of the Milan International Chamber of Arbitration. Now, Alexei's term finishes in a week, so it is a huge privilege for us to have Alexei with us today. And we'll be looking back at Alexei's achievements and the progress that has been made under Alexei's presidency. I saw recently, Alexei, that you mentioned one of the first events you attended as president of the court was a GAR event in Hong Kong. And I remember that was in October 2015. You were interviewed by Michael Moser, and there was a survey about whether the ICC had become a dinosaur. Now, here we are 6 years later, and the ICC Court of Arbitration has just been voted the most popular arbitral institution in the world, something I'll come back to. So, Alexia, on behalf of ICC UK, welcome. I'm going to dive straight into questions, if I may. So let's start with the first one. During your time as president, the ICC has promoted, among other things, transparency. So we've seen this in the new 2021 rules, for example, disclosure of funding in relation to funding agreements under Article 11.7. But even before then, we've had changes in the ICC's Conduct Note 2019 in relation to arbitrator disclosures. And the ICC, as we know, is now publishing awards. And you've also been publishing details of arbitrators from 2016. So my question, I guess, Alexia, is that job done, or is there more to do on the question of transparency?
Well, thank you very much, and good morning, everyone. It's a pleasure for me to be with us today, even though I would have much preferred to be with you in person, but that's what it is. To answer your question, first of all, yes, Guy, I remember vividly that event in Hong Kong, and I take some facts that today I do not think that anyone would organize or think to organize an event under that theme of whether the ICC has become a dinosaur, or whether we did good or bad. But I think we've been quite active in the past 6 years, and perhaps the ICC has shown that it is an agile organization, reforming its practices, adapting to new circumstances, and striving to always meet the needs of its users. Now, as to your question on publication of awards, is the job done? I think perhaps there are a couple of things that deserve to be mentioned. First of all, you mentioned the publication of awards on an opt-out basis. That has been quite a novelty in the arbitration world. It is, in fact, I think the first time an institution introduces policies such as that. It has raised some level of questions as to whether that's compatible with confidentiality or not, and we may come back to this. What we are seeing in terms of first assessment of how this policy is working is quite a high level of opt-outs. We have a significant proportion of ICC cases which are in any event subject to confidentiality clauses, about I would say 50% of them. On the remaining 50%, we are seeing more than 60% of opt-out. Nonetheless, those of you who have looked at the court website have seen that we have been able to publish a limited number of awards, only awards made, of course, since between the 1st of January of 2019 and at the end of June of 2019 are eligible for publication. We have been able to publish a limited number of awards with the names of arbitrators of the parties, subject to the minimum level of anonymization which is required by GDPR. My hope, and I'm sure in fact it's more than a hope, I'm convinced that will happen. We will see more awards published based on this practice, and I do hope that the principle of transparency through the publication of awards on an opt-out basis rather than opt-in, I'm sure that it will gain more acceptance in the future. We have planted a seed that will produce fruits in the future. I'm very convinced about this, and perhaps I would like to take the chance of reading you a quote which I like very much, and which is in my last editorial of the ICC Bulletin. It's an article which came out in the Financial Times weeks ago, more or less, and the title of the article is "A New Era of Corporate Transparency is Dawning," and the article concludes as follows: "An era is dawning in which most of what can be known will be known. Resilient institutions will get ready for these futures. That means delineating the very narrow areas such as personal privacy and genuine corporate and government secrets where confidentiality is necessary, while accepting even embracing that most information does not fall into that category. Successful companies will be those who can do their business as well in the open as in the dark. And I endorse 100% these words. I think they apply word by word to our two institutions. And another perhaps note on what on more transparency regarding the pressure of reasons. As you know, the practice now is that we
It appears we are having some technical problems with Alexi's line, but hopefully it will come back. Alexi, I think you're now back with us.
Okay, sorry, have I been cut off?
We lost you just after you gave us the article quote from the FT. So if you could pick up from there, that would be very helpful.
All right. So okay. So I was saying that I hope you were able to listen. The quote, I endorse it 100%. Another note perhaps is that perhaps the court will consider in the future whether to expand its policy on the provision of reasons for its decisions. We are doing this now only upon request upon one of the parties. Maybe in the future, the question may arise whether we should not do so systematically. Another initiative that would be welcome, I think, would be to publish. Now, so far, perhaps the bulk of decisions where reasons have been provided is too narrow, but in the future, it will become quite an interesting body of decision that could be an interesting publication. And perhaps there could be more information on the conduct of the proceedings on the website. Such as the length of the procedure, whether there's been bifurcation or not, and that kind of information. These are things. So there's always something more that can be done.
So I want to come back actually, because that's an interesting piece you've cited in the FT. And actually, I think it indicates perhaps absolutely a mood of a desire for growing transparency, but not necessarily one where all corporates have embraced it. So one of my questions around this move for more transparency is whether you're getting or whether you're seeing feedback from the corporate community that either supports or challenges the moves that ICC are taking.
On the publication of awards, I think that's what you're referring to. I think the feedback has been essentially agnostic in the sense that we have not seen from corporations an endorsement of the policy. There have been some concerns, of course, as to confidentiality, but I think that once corporations understood that based on the opt-out policy that we have adopted, they would be able to, in fact, object to publication at any time. And respect that, of course, we have also offered the possibility to companies of objecting in an umbrella way, in the sense to tell us that in none of their case that they want publish, and we respect that, of course, as well. I think that has alleviated their concerns to a large extent. Essentially, now users are agnostic about this, but I think there is a broader interest into this. It's not something that is done to meet an expectation of users. It's something that is done for other systemic reasons.
Okay, thank you. So there's another element to transparency, which is obviously transparency of ICC as an institution. And one thing I wanted to talk to you about was the appointment of court members. Now, it's very well known that one of the things you've achieved during your time as president is to get much greater much greater diversity among court members, which is to be applauded. But some people might not necessarily have an understanding of actually the transparency of that appointment process, or may want to know more about how they would be considered for appointment as a member. And I suppose my question for you, is this an area where there should also be more transparency for the ICC, so people know the way in which court members are chosen, and are we ensuring, for example, that in the future there will be equal diversity of choice across the court members across the world?
Yes, well, I think that there is information that is accessible on this, and perhaps is done too much on in different sections of the note, and it's not clearly understandable as it should be, but the information is there. The rules provide clearly for the principle that court members are appointed upon the proposal of the National Committee, that alternates court members are appointed by the World Council upon the proposal of the President of the Court. So that's very clear. There's been an evolution in the practice in this regard, as you know, which has taken place in 2018. But in fact, the evolution has been going back to the letter of what is provided into the rules. So that I think is very clear. There is now mention in the rules of the existence of the Bureau of the Court, which is composed, as you know, of the vice presidents, whereas before the Bureau had no official existence. It now exists. I have insisted a lot, and I think it will happen, if it has not already happened, for the composition of the governing body for the DRS to be made publicly available on the website. So all this is public. So how do you get to be appointed as an arbitrator is something that perhaps if more clarity can be given, that would be welcome. But again, the rules provide that arbitrators are appointed upon the proposal of one or more national committees. That's clearly said in the rule. It is also said in the rules that the court can always make a direct appointment in a number of circumstances, including when the state or a state entity is a party to the arbitration. And of course, beyond that, there is the guidance that all national committees provide, which is that in order to get appointed, you need to get yourself known, you need to provide awards, you need to, and that of course is obvious. One thing that is also included in the note to national committees is the fact that national committees cannot subject proposals made to the court to conditions such as being for the prospective arbitrator to be a member of the national committee or to pay something. This is of course strictly prohibited. So all this is publicly available. Perhaps the question would be to bring all this information in a single place on the website. But all this is already available.
Thanks, Alexi. I'm going to move on to a different topic now, which is technology. And I did a bit of additional research on what you've said on this in the past. And in 2017, at an ICC conference on equal access to information and justice online dispute resolution, you said there may be no more relevant topic than this one on the future of dispute resolution. So I'm reading into that's a topic of technology and on online dispute resolution in particular. Now, that was pretty prescient in terms of what's happened over the last year, but I suppose my question is, do you still agree with that statement in particular about online dispute resolution? And actually another question, if I can roll it all into one, which is, do you think the ICC is doing enough to modernize its processes to use more technology and to make a sort of technology more accessible in arbitration for its users?
No, I do stand by this statement. I think that these issues will become even more important if that can be than they are today. And the question has two aspects, of course. The first one is the support that the institution can offer to parties in terms of logistics, in terms of offering platforms for online hearings, a platform for case management. And we are doing this, although I think that we are not doing this fast enough. We still, and we are lagging behind on the question of the case management platform, which will be done, but we have been delayed by a number of technical questions. And in fact, the reality is that we still do not have an offer of the same kind as other institutions have, but that will be fixed. But it has to be fixed. On this, I think, are we doing enough? The fair answer is no. We should have done more, and we will do more. ODR is of course fundamental. One striking thing, and one thing that has really impressed me is the extent to which technology has evolved since the outbreak of the pandemic. platforms have improved immensely. And we will see the same for ADR. I'm completely convinced that in 5 or 10 years from now, there is an entire part of what the court does today. I mean, these disputes involving claims of less, I would say, less than $500,000 in the mountain dispute, for example, that threshold, all this will go to ADR in the future. It doesn't make sense to resolve this dispute through classical arbitration procedure, even if it is expedited, and I hope we'll come back to the expedited rules, because this is something in which I deeply believe. But we need something completely different for this dispute. Not to talk about something on which the ICC is not really a player in, which is a very small dispute and consumer dispute. But there are business disputes which are below that threshold of 500K, which need a completely different answer. And on this, of course, we don't have that answer in the ICC. I think that this is something on which the new court and Claude Solomon at the ICC will need to really focus their attention on.
And that's a very good segue actually into my next question, which was about the, which is about the expedited procedure provisions. So you presided over the court when these rules were introduced, I think in 2017. We've just seen that quantum threshold introduced, raised to 3 million. And maybe we'll talk a bit more about what you might have to do at the bottom end of that. But right now, my question is 3 million the right threshold? And actually, what feedback have you actually had in relation to the expedited procedure provisions? Are clients welcoming this? And should we, as counsel, be promoting this more to our clients as a really sensible option? Because one thing I have seen in a lot of the commentary is quite a lot of emphasis on the opt-out right in relation to it.
Well, let me see this. Starting with your first question, which is 3 million the right threshold. In my perspective, the answer is no. The answer is no. I had myself proposed a higher threshold in the process for the rules revision. I had proposed 5, and then 4, and it went to 3. It's kind of a compromise solution. It's interesting because what we have seen is it's really equal in the process for the rules revision, equal feedback from a number of very large users. Telling us, why 4? You should have 5 or 10. You should have a much higher threshold. This is a wonderful tool. It works very well. It is a meaningful answer to our concerns as to time and cost. You should be bolder and adopt a higher threshold. Other users told us, no, we don't want this. This is bad. This is going to be cheap justice. We don't want the EPP at all, or you should have a very, very low threshold. And we also had feedback from users in a number of developing countries where saying, well, you have to take into account currency issues. And for us, what is not a high threshold in the US or in Europe is very high. So you have to mediate all these concerns, and we adopted this treatment. What was important for me is that there would be an increase, because increasing the threshold was a signal to the market. Now, the EPP works very well. It works undoubtedly very well. There were, you may remember that a number of criticism when we introduced this in 2017, lots of skepticism. I think we have been vindicated by how it has worked from then. So far we have had about, I think, 120 awards made under the EPP. I think 70% of these awards have been made within the 6-month time limit, or with short extension. In other cases, either there was an agreement of the parties, or delay was justified, or there had been fees reductions according to our practice. So it works very well. And what we see is that the quality of this award is as good as that of any other award. And what we see is that the parties cooperate with arbitrators which are available, because we appoint availability, of course, in this context, a very important consideration for the court. So it works very well. And really, it is not only an effective answer to the concern, justified, legitimate concerns of users as to the time cost of the arbitration, it is also a return to what I would define as the lost promise of international arbitration, which is an effective, cheaper and quick way of resolving disputes. There is no reason in the bread and butter of commerce with claims of $2, $3, $4 million involving termination of a distributorship agreement. There is no reason to go to a 3 years arbitration with hundreds of thousands of dollars in fees, with parties ending up paying in fees and costs at times half or more than half what their interest is in the case. That doesn't make sense from an economic perspective. So I'm a deep believer in this system. I hope that the threshold will be increased again in the future.
Thank you. I would love to ask more questions about that, but we've got just under 5 minutes left, and I've got some other questions I want to come on to. So I mentioned in the introduction that the ICC court has just been voted the most popular arbitral institution in the world. That was in the recent Queen Mary University study. So first of all, congratulations, because that happened under your watch. So a good thing to get under your belt before standing down. But what we see is really stiff competition now among institutions, but also venues. Here we are with the ICC UK conference. And for the first time, that report put Singapore and London as the joint first most preferred seat, with some suggesting that that's an indication that perhaps the dominance of London as a seat of arbitration is under threat. Now, actually, Paris dropped as well. And so there's an interesting question as to whether or not that matters for the ICC court, because, of course, it's a global institution. So my question is, does the ICC have a responsibility to promote any particular venue, or is it venue ambivalent?
No, the short answer to this, and I'm mindful of time, is the court has... It is not part of the court's goal to promote a venue as opposed to another. We are a global institution, and in fact, it would be a mistake for the court to engage into promotion for a particular venue. We are, to the contrary, aiming at favoring diversity between venues. We see the rise of Singapore as a very, very positive development for international arbitration. As a whole, we hope that we will see other venues in Africa in particular rising in the future. So the short answer to the question is no, it is not part of our goal to promote Paris or London or New York as opposed to other seats.
So let me ask another question on this topic. Singapore has come up, London has stayed where it is. Paris dropped a couple of rankings. Now, this is only one survey, but you'll have a view in terms of preference of venues across all ICC arbitrations. Is this a trend away from civil law jurisdictions in favor of common law jurisdictions?
Well, what we see in terms of ICC statistics is a bit different, because London, the UK, was #1 in 2019 with 115 seats. 2020, it's #4 with 85. Paris has receded as well. The US has risen quite significantly, as well as Brazil and the UAE. Singapore, in our statistics, 2019 was 32 and 2020, 26. So you have to mitigate a little bit the numbers. I don't see that we see what you say, a shift away from civil law venues in favor of common law venues. What we are seeing is a much more diverse landscape, and again, that is very good. That is very positive. I think one of the great stakes for the future will be to see the rise of a strong African arbitral venue in the future. Mauritius is doing lots of efforts, of course, but I think there are places in the continent as well which have all the titles to become a reliable regional and international venue.
And actually, that was a topic we covered last year with ICC UK, where we had a specific focus on arbitration in Africa. And in fact, you're right, there are a number of jurisdictions that are putting a lot of effort into this. Right, I'm going to ask a question now, which relates a little bit to your successor, Claudia Salomon. So she's taking over next month. She'll be the first female president of the ICC court. Now, you said in a previous interview, now this was actually in relation to arbitrators at the start of their career, that you don't tend to give advice. So I'm not going to ask you to give advice to Claudia, but let me frame a question in a slightly different way. What do you know now that you would like to have known at the beginning of your presidency about running the ICC court?
Well, yeah. You know, in leading an institution like in politics, you never know really how things will unfold. You have to adapt. No one can pretend to know what the future look like. You will have to face unforeseen events, unforeseen developments. What you need when you start in a position like this is, and I'm sure that Claudia has that, is a clear view of the principles on which you want to rely in your policy, where you want to go, where you want to lead the institution. When I became the president, I had the dream of bringing this institution to 1,000 new cases per year. We're not quite there, but almost. But more importantly, we have, I think, worked in the past 6 years on a limited number of very clear lines of policy: transparency, ethics, diversity, increasing the efficiency of our services. And I think that any institution needs continuity as far as the broad principles of its actions are concerned. So I do hope, but I don't have any doubt about this, that the new court will ensure that this continuity exists. Beyond this, you know, Madame de Sévigné said, quand je n'en fais qu'à ma guise, je fais des merveilles. And I'm sure that Claudia Salomon will do the same. She will do things in her own way, and it will be very good. She's a very, very talented and skilled leader. Have no doubt whatsoever that she will find ways of helping the ICC and not only survive but develop and remain the most preferred arbitral institution in the world in the years to come.
Thank you, Alexei. We've had a couple of questions from the audience, and I think there's one that I really should pick as perhaps the final question, because here we are. You've got a week to go. So, question from the audience: what 3 achievements are you most proud of?
Well, first, to come back to the beginning of our conversation, I'm quite glad that today no one would suggest that the ICC is a dinosaur. That's in itself a good thing. I think that the ICC and the court are in a better place today than they were 6 years ago. Diversity is something, it's not been easy, in particular gender diversity, to impose in a way that we would have 50% of women in the court. We should not forget that 20 years ago, or 15 years ago, there was only one woman in the court. That was our friend Antonis Melitza. Now we have gender parity. In fact, the new court has slightly more women than men, which is good. And that is due to the fact that we have done this effort back in 2018 by imposing appointments. Now we have the basis. We have really created a generation of women practitioners that are excellent, and in fact it's been very easy to achieve gender parity this time. So that is an achievement. I think it's imperfect in the sense that, as Harry said at the beginning, we still have a lot of work to do in terms of regional diversity in particular. The number of sub-Saharan arbitrators that are appointed in ICC tribunals is a shame. It's very, very low, less than 2%. We need to do something about this. We need to promote arbitrators from rising jurisdictions. We need to be more audacious in appointing young arbitrators. So it's still a work in progress, but I'm quite proud of what has been done on that front. And perhaps the EPP, which I mentioned before, is something I'm very proud of, because it met a lot of resistance at the time, and really I had to fight against it politically, to convince, to impose decisions as well. And it's always, something when you do something like this, you say, okay, well, what about if I'm wrong? But this is something with huge consequences. But that proved me right, and I'm quite happy about this.
Alexei, thank you very much. Unfortunately, we've run out of time. In fact, we've gone slightly over, so I hope we won't get into too much trouble from Anya, but hopefully you can stay later, because we may have a few more questions from the audience. But on behalf of everyone here, on behalf of ICC UK, Alexei, thank you very much. Thank you for spending your time, and congratulations on a very successful presidency.
Thank you, Guy.
Thank you so much, Guy, and thank you, of course, to Alexei for sharing your insights with us on all of the changes that we have seen come in under your leadership. So now it's my pleasure to introduce Emily Monastriotis and Sebastian Pepin. Emily is a partner at Simmons & Simmons, and Sebastian is counsel at the ICC. And we are going to focus more specifically on the changes to the ICC rules that we saw come in on the 1st of January of this year. So, but before I start with questions to you both, let's try and get some involvement of our participants. So hopefully the poll function is working on your swap card. A question to the audience. So the new rules came in, about 6 months ago now. And of course, they were announced as another step towards an even more efficient, flexible and transparent process. So the question to you is, do you think that the revision to the rules have achieved what they set out to do? And of course, we heard directly from Alexei about those clear principles of efficiency, flexibility and transparency, and of course also diversity that he had a view to during his presidency. So the question has gone up, and I think I will let you answer that at your leisure, because we will be looking at the answer to that poll at the end of this session. So first question to Sebastian for the ICC perspective. The new rules allow a tribunal to order virtual or remote hearings. We've heard a little bit already this morning about this from Alexei, but can you tell us how many hearings have been taking place virtually, in particular since this new provision came in?
Thank you very much, and good morning. It's a pleasure to be here with you all. So we don't actually have statistics on the amount of virtual hearings that are taking place, or the percentage. What I can, however, maybe provide insights into is my experiences as case manager at the Secretariat. And that has been essentially that at the start of the pandemic, we saw that most tribunals were postponing, in particular, evidentiary hearings until a later date, until the summer, or sometimes a little bit sooner, as we were waiting to see maybe the extent of the pandemic and how long it would last. And what we started to see in our cases roughly around the summer is tribunals more and more reluctant to postpone further the organization of hearings, and proposing to parties a backup solution of having virtual hearings. And really it became the norm, I guess, around fall of last year, where I would say a majority of hearings were taking place virtually. And that is both procedural hearings and evidentiary hearings. And I think it reflected, first of all, the fact that the platforms were becoming better and better and more able to cater for the needs of such hearings. It was becoming apparent that this, crisis could affect our operations for quite some time. So that's sort of my perspective from the inside. But I can't give you any rough figures. What I can say is that procedural hearings, it's always been a possibility, and it's continuing to be in the majority of cases. For evidentiary hearings, for now, it's a majority. It would be interesting to see how that develops as we near, hopefully, the end of the pandemic, and we're able to resume something close to our normal operations.
Thank you so much, Sebastian. And over to you, Emily, for the user perspective, hopefully. Now, Emily, a tribunal could, under this rule, order a virtual hearing in circumstances where the parties may disagree. Is this, from the point of view of the users, a potential breach of party autonomy? And are parties in some instances going to miss out on a fair opportunity to present their case properly?
Yeah, I mean, obviously it's taken a crisis for us to be able to operate in a more virtual world. And I suppose picking up on what Sebastian said, I think the reality is that this rule is essentially regulating what's been happening on the ground anyway. I think just to pick up on a couple of points on the rule itself, I think there's two things that one needs to flag. Firstly is that the tribunal has to consult with the parties, which I think is very important because it gives you the opportunity as a user to put forward your views. And it also expressly requires the decision to be made based on relevant facts and circumstances. So it's not arbitrary, which I think really gives comfort. And again, kind of from my experience, I mean, we've all been kind of pulled into virtual hearings, whether or not we like it, over the past year or 18 months. I mean, it's gone like a flash. But I do think that one thing that is really important, and I've certainly my experience of acting in ICC arbitrations, this is very clear, is that setting the ground rules is very, very important. We're seeing very lengthy hearing protocols, which can be helpful, although sometimes can perhaps be overly prescripted, a bit of a kind of tough balance to achieve there. And I do also, we've seen kind of some stark examples of tribunals trying to level the playing field, and for example, ordering all participants to be remote. So personally, I'm not concerned about a fair opportunity because if anything, COVID has really leveled that playing field.
Thank you, Emily. And I'm going to move on to now Article 17.2, which allows the tribunal to limit a party's ability to appoint a legal representative of its choice in certain circumstances. So, Sebastian, maybe you can talk a little bit about the reasons behind this rule.
Yes, absolutely. Thank you, Anya. And I think, yeah, this is one of those provisions which may have raised some concerns, but I think with the proper explanation, it's quite a natural progression, and it's sort of a codification of what happens in practice in any event. And essentially, this addition to the rules recognizes the express power of tribunals once constituted to act upon changes in party representation, which may give rise to conflicts of interests. So it really aims to address issues of party representation that may otherwise lead to the filing of challenges against arbitrators upon grounds which would otherwise lie beyond their control, and which the court has unfortunately in the past had to accept on a number of occasions. So it's something which is responding to what has occurred in practice. And it also dispenses with the need to have such a power being expressed in the terms of reference, because this is, we've seen a number of tribunals try and include this in terms of reference, because it does appear to be sound practice, and it's not always accepted. So this is sort of formalizing it in the rules, what appears to be, broadly speaking, sound practice. So essentially, it responds to these situations that may have arrived where counsel is appointed late on in the proceedings, specifically to create a situation of conflict of interest with an arbitrator as a tactic to either derail or delay the proceedings. And now, with the inclusion of this provision, the tribunals have a greater power to prevent this from disrupting the proceedings.
Thank you so much, Sebastian. Emily, is this a cause for concern, or is the provision welcome?
Yeah, again, coming back to kind of what Alexis said and you picked up on, I think many of the fact in terms of the rule changes had in mind kind of efficiency, flexibility, transparency, and I think you also said diversity. But I think there's another important point really to pick up, which is enforceability, as Sebastian says. So I think this particular rule does aid enforceability and also aids transparency. But again, from a user's perspective, you do need to balance that against the concern that the institution shouldn't be given too much power. At the end of the day, arbitration is meant to be consensual after all, and we have the kind of autonomy principle. But I do fear that such rules, this particular rule, is a necessity to avoid some of the games that Sebastian's just spoken about that we sometimes see, thankfully not too often, in international arbitration. Again, I do think it's important to flag that the power can only be exercised after the parties have been given a proper opportunity to comment in writing. So again, from a user perspective, I can absolutely see what this rule and this rule change is there to achieve, and I'm not too concerned about it.
Thank you so much, Emily. So similar theme, moving on to Article 12.9. Under this new rule, the ICC court can, in exceptional circumstances, deviate from the parties' agreement on the method of constitution of the tribunal, and in fact appoint the entire tribunal. And this rule has seemed to have sparked some discussion in the commentary, some concern. So Sebastian, maybe you can allay some of that concern and tell us, when in practice will this rule be applied?
Yeah, I think this is an interesting one. Again, a common theme with these new rules is that it fine-tunes some of the practices that were already taking place at the court, and this is precisely one of those examples where there was a provision under 12.8 which provided that the court had the power to appoint all members of the arbitral tribunal if the parties could not agree on the constitution of the arbitral tribunal. Article 12.9 covers a situation where there does appear to be an agreement on the constitution of the arbitral tribunal, but that agreement itself creates a situation of imbalance or unequal participation in the constitution of the tribunal, which could endanger the enforceability of the award. So what I mean by that is we've had situations where the arbitration agreement itself provides that 3 respondents will each have the possibility to nominate a co-arbitrator, and the claimant will have the possibility to nominate a co-arbitrator. And by applying the arbitration agreement, it creates a situation of imbalance in the procedure that needs to be restored. What used to take place is that the court would resort to its broad powers under Article 42 of the rules, which allows it to take any measures that would be otherwise contrary to the spirit of the rules. What's important to remember also is that this provision will be used it will be used sparingly, and it will be used according to the jurisdiction that is affected. So I think very tellingly, there is quite a difference in this respect in between France or French courts and English courts, because in France, any unequal participation in the constitution of the arbitral tribunal can only be agreed upon by the parties after the dispute has arisen. Any attempts to arrive at an agreement before the dispute has arisen, and that provides an unequal right for the parties to participate in the constitution of the tribunal, will be considered invalid as a violation of public policy in France. Whereas I think, at least up until recently, and I don't believe this has changed, is that the English courts would generally recognize the validity of an arbitration agreement, even if it provides for a certain imbalance in the constitution of the tribunal. I think there are certain caveats to that, but broadly speaking, the practice can be different according to different jurisdictions. So the court will bear that in mind when it potentially applies this new provision.
Thank you so much, Sebastian. So Emily, it's going to be used extremely sparingly, we've heard, and primarily to protect the enforceability of awards. So from your perspective, is it a cause for concern, and is the right of the party to nominate its choice of arbitrator a fundamental right in arbitration?
Yeah, and just picking up on Sebastian's point in relation to differences between systems, because I suppose obviously I approach this from an English law perspective, and from an English law perspective, the principle of party autonomy, which is legislated for in the English Arbitration Act, prescribes the right of the parties to decide on all procedural and evidential matters, including how the arbitral panel is appointed. But we have to recognise that the ICC is an international institution, and you do have to draw a distinction between the English law approach and those of some other civil law jurisdictions. And as Sebastian said, the French system is different. So my understanding, and I'm not a French lawyer, so happy to be corrected if I'm wrong, is that, for example, in France, the principle of equality of the parties comes above party autonomy. And that is something that is reflected in the French Code of Civil Procedure. So I think that the amendment of the new rule, I think, adopts the non-English approach, if I can call it that, because as you said earlier, Anya, previously, it was only the court that appoint each member of the arbitral tribunal, specifically in multi-party arbitrations, where all the parties were unable to agree on a method of constitution for the tribunal. But as the ICC says, this rule is driven by the desire to ensure the validity of the award. And again, it's there to tackle enforcement issues. Again, I personally take a lot of comfort for the fact that it's only to be used in exceptional circumstances. But as an English lawyer, I can't help but say that I'll be keeping a very close eye on how this actually develops in practice.
Thank you so much, Emily. So moving on to a slightly different topic, but they're also still on the theme of transparency, of course. Article 11.7 requires the disclosure of funding arrangements by parties to an arbitration. So Sebastian, could you talk a little bit about what the thinking was behind this particular change?
Yes, absolutely. Again, this is meeting or responding to what has occurred in practice. So it obviously, first of all, it addresses the increasing use of claims funding in international arbitration as a source of potential conflict of interest. Third-party funders have become a reality in international commercial arbitration. And these third-party funders can have significant influence on the decisions that are being taken in the course of the arbitration. So the purpose is, again, to preserve the arbitrator's independence and impartiality, so as to ensure the sanctity of the proceedings and the enforceability of the award. And I think that's fairly clear by its inclusion under Article 11 of the rules, which deals precisely with arbitrators' confirmations and their duties of disclosure. Now, the note had previously clarified that a relationship between an arbitrator and an entity having a direct economic interest in the dispute would be required to be disclosed. And I think that there is a similar disclosure obligation that already existed under the General Standard 7 of the IBA rules on conflict of interest. So this is, again, the consecration of what appears to be a necessity to cater for certain challenges that have arisen and that have been dealt with by the courts in relation to potential conflicts of interest that are arising from third-party funders. What we have already seen in practice before the new rules were that there were several decisions by arbitral tribunals in relation to funding arrangements. So this provision doesn't aggrandize the arbitral tribunal's powers. It's really rather an obligation which is placed on the parties to ensure that any such information is provided as soon as possible to avoid any issues with respect to the constitution of the tribunal or with respect to the enforceability of the award.
Thank you, Sebastian. Emily, is this new rule been welcomed by users, or again, are some expressing concern?
Yeah, I think there is clearly a recognition that third-party funding is becoming much more prevalent in international arbitration, and I think there's an acceptance that this change very much has transparency in mind and the driver to ensure enforceability of the award. In one way, it can be said to be too narrow because it doesn't appear to capture all funding available. So in the notes to the parties, it says that this article wouldn't normally, for example, capture fee arrangements between a party and its counsel. But from an English law perspective, there is, I think, one concern with the rule, and that is that it could, and it's a concern by insurers, because currently under English law and the provision of services regulations of 2009, you have to disclose the contact details of the insurer or a guarantor and the territorial cover of the insurance and the guarantee. But that's subject to one very important proviso, and it's subject to a requirement to hold any professional liability insurance. So I think the concern really that arises is that the rule takes a step further and in certain people's eyes a step too far. But my personal view is it's a relatively limited disclosure. It's limited to the existence and the identity of such a party. So I think you can kind of over-exercise your mind in relation to it when in fact it is a limited disclosure.
Sebastian, I see you nodding. So I assume you're agreeing with what Emily just said. Do you have anything to add in response to Emily's comments?
Yeah, I think the most important point is precisely the information. First of all, it should be at the initiative of the party. Its purpose is to avoid any issues of conflicts of interest, and we've already seen decisions by tribunals that specifically curtail or limit what needs to be disclosed, and very much sticks to the wording, which is the existence and the identity of any third-party funders, rather than the underlying agreements or anything of that kind. And I think also, as I mentioned earlier, the tribunals already had broad powers under Article 22 to take any procedural decisions or other that it considered necessary. And we already had decisions from tribunals that concern funding arrangements. And I think a tribunal must take into consideration the applicable law and any protections that are granted under the applicable law when taking any decisions with respect to the disclosure of funding arrangements. So I don't think this provision and rules will revolutionize or change that, and so I think that can allay hopefully some of the concerns that may have been raised, in particular in the insurance industry.
Thank you so much, Sebastian. And I see we're running out of time. So let's move on to the publication of awards. And of course, Alexei covered this in his interview. As we know, the 2019 note introduced a revised approach to the publication of awards. So Sebastian, any additional thoughts to what Alexei said on how this has worked so far? And of course, we heard from Alexei that many are opting out. So, how many of these awards are actually being published?
So, I mean, the first awards are being published as of this year. So I guess we are only now starting to see figures come in and awards being published. It's quite early days to be drawing any conclusions, but at least in theory, there are roughly 70% of awards that are not publishable, and that is either because there is a confidentiality agreement, either in the underlying contract or in the terms of reference, which requires a positive consent of both parties for the award to be publishable, or the parties have objected, or either party has objected to the publication of the award. So that means that we're looking at roughly 30% of all awards that are rendered in ICC arbitration that are publishable, and then there is a further filtering process which takes place, and that goes through first of all at the court and at the secretariat. We will look at some of the particulars of the case. Namely, there are certain cases that are unpublishable by their very nature. Those are compliance cases, cases involving states and state entities, certain sectors of industry. The court will also look into the certain industries where there are so few players that it will be evident which parties are behind the anonymity of the award. So there are various checks that take place even after the award has been rendered. And the last one is that there is this practice of communicating the award to the party before its publication. So there are also last minute or late objections to the publication, which are possible. So I think the main point being that there are many instances where the party will be given the opportunity to object, and so the idea is not to I guess circumvent or override the confidentiality desires of the parties, and that is first and foremost safeguarded by the fact that the entire system changes depending on whether confidentiality is already included in the underlying agreement or in the terms of reference, and that ultimately the parties will have ample opportunity to raise any objections they may have to the publication of the award.
Thank you, Sebastian. You only have about a minute, Emily, but I'm keen to hear your thoughts. Are there enough safeguards in place? And many users will have chosen arbitration for its perceived privacy and confidentiality. So, is the publication of awards something that may concern them?
Yeah, I think there are a number of issues to unpack here, and I'm not sure I can do them all justice in the minute. But I think, first of all, the change came through an updated practice note rather than an amendment to the rules themselves. So I think that of itself may have taken practitioners by surprise, but setting that to one side, there is a really fine balance, isn't there, between confidentiality and transparency. I think the process is really important to note because you have notification, then you can object, and And if a party does object, then significantly, I think that party's wishes are respected, and either the award won't be published at all, or be anonymised or pseudonymised. I think it's also important to flag that if there is a confidentiality agreement in place covering the arbitration, then it kind of, there's a flip, it becomes an opt-in procedure, so the parties have to consent to that procedure. So I think, given the kind of really fine tightrope between confidentiality and transparency, I think the procedure works well, but it works well because it allows you to opt out, and you just need to make sure that you are aware of the issue. I have to say, I'm not surprised by the figures that we've heard from both Sebastian and Alexis in relation to the high number of opt-outs, but I think on balance, fair, but you just have to make sure it's something that you are aware and take early client instructions on.
Okay, thank you so much, Emily. So I'm hopeful that the system won't cut us off. I think we have a tight deadline of 10:20. So I'm going to quickly look at the poll. Not all of you have answered, so I'm hoping that maybe Natalie and the ICC UK team can keep the poll live even after our session. I don't know whether that's possible. But for those of you that have answered, interestingly, 50% think that the rules do achieve what they set out to, and 33% think that they could go even further. So just before we do get cut off, perhaps Emily and Sebastian, you could tell me what your answer to the poll question would be. Yes, no, could go further, or not sure. Maybe Sebastian, you first.
I think it's well, again, there's obviously the rules, and then there's the notes. So I guess
we're going to stick to the rules, and you're going to have to give me a quick answer. So.
Okay. Well, I'm going to pay homage to our president. I think definitely this initiative from the court has been very positively received, and hopefully it will continue to be. So I would say
yes, and could go further.
I would say yes.
Yes. Emily?
I'm going to say it's evolution, not revolution, but it's still a yes from me.
Fantastic. Okay, I think I probably have just enough time to thank all of our wonderful speakers, and a big thank you to all of our participants that are watching us live. And of course, hopefully a lot more will be watching the recording at some point later today or during the end of the week. And over to you, Natalie.
Thanks, Anya. Thanks ever so much. It's been a great session. So just to confirm, all the webinars are still available, will be available and accessed via swap card, and they will also be available on demand afterwards. So if someone's missed a session, don't worry, you can log onto your swap card account and gain access to them there. The next one will take place today at 12 o'clock on MedArb, the best of both worlds on unnecessary intermediary, which should be a good session. So we look forward to seeing you soon. Thank you, everyone, and take care.